Greetings, this is Management 431, the third lecture, which is the legal context, dealing with all of the legal issues related to strategic staffing. We have covered legal issues, I think, fairly extensively in Management 430, but it really starts to compound and grow when you think about the impact of the law on staffing decisions, whether we're dealing with disparate treatment or adverse impact, whether we're making hiring decisions based on race or sex or religion. We have to be incredibly careful. Saying, gee, I didn't know is not really a defense in organizations, and so it's incredibly important that you understand the impact of the law on the hiring process. This is important whether you're going into HR or whether you're a manager. Specifically, if you're a manager, you're much more likely to step in landmines and make mistakes that you didn't realize were incorrect behaviors. And so it's important that you work on that and understand it. So this chapter is really extensive. It's broken down to a couple of different parts. Simply because it's just so extensive, it's important for us to make sure that you understand it well. So in terms of the learning objectives for this chapter, there's a handful of them, of course. Number one, to understand why complying with staffing laws can be strategic. How complying with the law helps us to achieve our strategic objectives. And so we'll get into that in a little bit more detail. We can talk about also the different types of employment relationships. We've got part-time workers, full-time workers, temporary workers. We can have contractual relationships, union-based relationships, at-will relationships. There's a lot of different relationships that we need to account for, and the law applies very differently depending on that. Next, we want to be able to look at and understand different staffing-related lawsuits to be able to know the difference between what is appropriate and legal behavior and inappropriate or illegal behavior so that we can avoid the lawsuits. That's the goal. We want to talk about affirmative action and the equal employment process and how affirmative action is not as negative as you hear about it in the media, that affirmative action is about making sure that we are attracting qualified people, a diverse pool of qualified people to our workplace. And that doesn't mean that we don't work on attracting men and Caucasians, but that everybody needs to feel like they have equal access to opportunities in the company. Lastly, we want to talk about the barriers for legally defensible systems, staffing systems, specifically what kind of things will you face on the job that may create a challenge for you to be able to meet your legal staffing requirements. So all of these are important learning objectives, and we're going to work through these section by section. So in terms of how legal compliance is strategic, well, first and foremost, the most obvious is that when we are mindful of the laws and we are following the laws, we avoid the expense of lawsuits, or at a minimum, we minimize the expense of lawsuits. I mean, there's only so many things we can do, and people are still going to sue no matter what. But if we can minimize our liability and do the right thing legally, ethically, we're in a much better place, and that benefits us strategically. Think of your organization. If it's in the news all the time because people are suing them for discrimination or lack of diversity issues, they will struggle with being able to attract qualified people. And so if you can't attract qualified people, that's going to have an impact on your strategic objectives. So we want to minimize our lawsuits. And again, get rid of the negative public relations, because we then can't attract people. We cannot have a good reputation and a good brand out there. Next, it allows us to show how diverse we are and to capitalize on the strengths that diversity brings. We all know diversity can be challenging because diversity can create more conflict. But if we make the effort to teach people how to communicate with each other, teach people how to negotiate and work through conflict. We'll find that there's much better performance on the job, and we will benefit from diversity instead of having it act as a liability for us. Lastly, you never know where you're going to find your next best, greatest employee. If we are only hiring people who are white males, for example, or white females, or black women or black men, whatever that is, whatever group, you're only hiring from a small segment of the population, and you don't know where that next best employee is going to come from. So it is really important that we try to utilize all segments of the population, and we work very hard to identify quality people who are going to be able to do the job for us, but we want to make sure that we are opening up our doors and broadening our pool so that we can have the widest variety of an applicant pool possible to hire the best person on the job. So those are the reasons and how legal compliance affects strategic objectives. This next slide, why do employment laws exist, should not be a surprise for you. Typically, we recognize that employers have much more power in the employment relationship than do the employees. And so we understand that's one of the reasons why unionization occurred in this country, because employers had so much power. They were treating workers poorly, having them work 6 or 7 days a week, minimal vacation, minimal pay, lots of accidents. And so unions came about to be able to address some of these disproportionate power issues. But from there, other employment laws have come up to help address the systemic discrimination that has occurred in the United States for women and minority ethnic and racial groups. And so the goal here is to try to just level the playing field. So the best person gets the job, not just the person who has the right race or sex that makes me happy, or religion that makes me happy. The goal here is fairness and consistent treatment. So treating everybody appropriately under the law so everyone has equal opportunity. That's really our goal in the long run. What value is there to the organization for complying with employment laws? Well, number one, it enhances our hiring quality. When we treat people fairly during the hiring process and afterwards, that word gets out word of mouth. So people start to know this is a good company to work for. They treat people right. They are honest and fair with people, and that helps us to have better quality hires because we're going to attract the best people. It enhances our reputation and our image. It promotes fairness perceptions among job candidates. It reduces what we call spillover effects. For example, if you go to a company and you're treated poorly and you're rejected, you may no longer want to use them for services or buy products from them. If you go into an organization and you try to work there and they don't treat you well, you're less likely to want to buy from them, and then the word of mouth gets out. You tell 2 friends and they tell 2 friends about your experience, and then they are less likely to want to buy from that company and or work for that company. Employment laws also reinforce an ethical culture. And again, the ethics and the law go hand in hand. It's really important for us to make sure that we have an ethical culture that also abides by the law, but also holds people to a higher standard. The law is the minimum that we can do. We can always do more than the law says. We can do better. The law sets the basement that we have to minimally achieve. But we can always do better. So I think in some circumstances, having a good, strong ethical culture is a big part of helping us to be the best organization we can be legally and ethically. Complying with laws also helps enhance our performance so that we make sure that we're hiring people who are the best person for the job based on qualifications, not biases. And also complying with the laws helps us to promote better diversity because then we're not limiting our selection pool and our applicant pool to only certain groups, that we're broadening and opening it up to everybody. As I said in the opening slide, we have different types of employment relationships. We have employees who can be part-time or full-time, paid by wage, paid by hour, paid by a strict salary. They get paid in exchange for doing personal services. And they work not independently. They work in conjunction with the organization. And this is different than the independent contractor who performs services wherein the employer controls or directs only the result of the work. So the difference between an employee and a contractor is that an employee can be told exactly how the work should be done, where it should be done, how fast it should be done. And the contractor basically is told, this is what I want as the deliverable, and the contractor can come back and say, I can do this in 3 days for this amount of money at this level of quality, and then the organization can choose whether or not they want to have a relationship with them. Independent contractors are consultants. They work on their own. They run their own business, and they are responsible for all their own taxes and Social Security related issues. Employees have a more intimate relationship with the organization, and they are much more responsible for the how as well as the what in terms of the process and the outcome when it comes to work. And that has to be done in conjunction with direction from the employer. Contingent workers are anybody who does not have a long-term ongoing contract. And what I mean by ongoing is even though an employee can be at will, the assumption is that they will continue to work until they're told not to. Whereas with contingent workers, there is a clear end date or a clear limitation to the amount of hours that they can give. So temp workers are not employed by the organization, but are employed by a temporary agency. They are only lent to the organization. And this is the same thing with leased workers. They are leased to the organization. The leasing company or the temporary agency is responsible for all the employment obligations. It is important to note that even if there are temporary and leased workers, the organization is still responsible for treating them fairly based on equal employment law. They cannot discriminate against them. They cannot harass them. They cannot treat them differently because of their race or sex or religion, et cetera, et cetera. Part-time and seasonal workers, it's like, Christmas time comes and Macy's hires more people. We want to make sure these people know that they're not going to be having an ongoing contract. It's only for a short period of time and then they will be let go. Some part-time workers have an ongoing part-time contract. That is less common, but it certainly can happen. But you can have employees that say, I only want to work 25 hours a week. That's all I'm going to do. And so you can have an ongoing relationship 25 hours a week, for a long period of time. But of course, when cuts are to be made, the cuts are always made with your part-time workers before your full-time workers. And so there is a lot more ambiguity for the part-time worker over the full-time employee. Next, you have union workers, and again, the union, they are members of the union and they have to be paid based on union wages, union rates, under union laws and union rules, and so that relationship is much more of a contractual relationship. It's organized under collective bargaining, and even though the unionized worker is a member of the union, they do work for the organization, but they are represented by the union, so that makes it a more complex relationship as well. And then lastly is the outsourced work, which many times is done by independent contractors. But if I outsource work to, another company, they are responsible for managing the work process. I only want to know what the work output is going to look like. And it works very similarly as independent contractors do. Employment at will is a really important principle for employment relationships. Basically, it argues that either party, whether it's the employer or the employee, can terminate employment at any time for just cause or no cause or any cause that is not illegal, and there's no liability with that. Of course, there are certain things that need to happen. You still need to be able to treat people legally, fairly. You cannot try to let them go in bad faith. For example, claim it's employment at will. The first day that a woman claims that, says to you, I'm pregnant and I'm going to need maternity leave in a few months. And you can't turn around and go, oops, well, I'm sorry, I'm letting you go. It's at will. Again, the contiguous nature of the employment, the pregnancy announcement, and then the being let go at will really is called into question for the organization, and they are more likely to be found guilty of pregnancy discrimination in those sorts of situations. And so again, you don't want to fire somebody the day before they're supposed to retire, or just say, well, sorry, employment at will, so you're not getting your retirement now. That doesn't work either. You want to make sure that you are following a very formal discipline and termination procedure, regardless of employment at will. You want to follow this because you don't want to take any chances of, again, legal liability issues, of making mistakes and doing things that are inappropriate based on race, sex, bias, whatever that might be. It's best used as a legal defense to keep the organization from being forced to follow its own policies inflexibly. So the goal here is that employment at will is a way to help the organization demonstrate that it's following the laws properly. And that they're doing it consistently. And, again, if you're saying that you have a policy, but then now you're saying, well, I'm just going to let you go because it's at will, that shows that that's inappropriate. Signing an employment application or an acknowledged receipt of an employee handbook is considered to be contractual. So the things that are in that contract, that are things that are in that handbook or that are written on that employee application are evidence of an agreement between the employer and the employee. So be careful what you put in writing. It's important to make sure you acknowledge that. There are a few exceptions for employment at will. Number one is retaliatory discharge, which is basically if somebody files a sexual harassment claim against the organization, you can't turn around and fire them because that's considered retaliatory. And that's prohibited under EEO. You also cannot exercise employment at will if there's an implied employee contract. For example, personnel policies or handbooks are great examples of implied contracts. So be incredibly careful about the wording of your policies, the wording in your handbook, so that you don't have any issues with that. You also want to make sure that you are not engaging in bad faith and unfair dealing. So there's an implied covenant that we're going to treat people right, we're going to treat people fairly. And a great example is what I had said previously, but I'm going to be repeated here. You don't fire an employee the day before or the month before they're supposed to be fully vested in their pension plan because you don't want to pay them their full pension. You don't fire somebody who suddenly tells you that they're pregnant. So there's good faith and fair dealing. You treat people right, you treat people fairly, and recognize that the timing of events is really key in court. That if something is timed, that someone makes an announcement to you that they've whistleblown or they are filing charges of discrimination against someone, and then suddenly you decide that they're going to lose their job from at will, it still looks fishy. And so those sorts of things really call into question the company's motives, and then that limits the at-will situation. Lastly, you want to make sure you recognize that federal or state discrimination protection supersedes at will. So here's an example. In Illinois, people who are gay, lesbian, bi, and transgender are protected against discrimination here in Illinois, but they are not in Missouri. So they could be let go at will in Missouri And they don't have to give a reason. They can just be let go because someone found out they were gay or lesbian. But in Illinois, that's not possible because the state legislature will protect them from discrimination. Typically, this is done through a collective bargaining agreement that the union represents them to do. With respect to unions, there are 4 basic union models. Number 1 is a closed shop, which by and large is not really legal. Like you can't have a company that has to only hire from a union, but a closed shop can be set up in such a way, like they say here, with a compulsory hiring hall, where if you are a union building and there's a union contract in place in a building, for example, when I used to work in Rockefeller Plaza in New York, it's a union plaza. So all the workers who can be unionized needed to be unionized in terms of electrical work and plumbing and things like that. And so the employer can only hire people who are members of a union or, in that respect. But those are rare. A union shop, though, employs both union and non-union workers, but new employees must join the union after a period of time. An agency shop says you can be non-union even if there is a union involved, but you have to pay a fee to the union, sort of a maintenance of contract, a maintenance of membership contract to be able to have negotiation on behalf of your benefits. So you benefit from the union even if you're not really paying the full dues. You pay a nominal amount in acknowledgement of the fact that the union is helping you with your wages and bennies. And an open shop basically doesn't discriminate. You can be a member of the union or not, doesn't matter. Everybody benefits from it, and no one has to necessarily contribute to the union if they don't want to.